So if you're not aware, the Supreme Court of Missouri will be ruling on COVID misinformation and if it is protected free speech or not. And just the existence of the case itself might have painted us into a damned if you do, damned if you don't type situation. And the crux of the issue is going to be what was so astutely pointed out here, in that who is going to define what misinformation is. Because for people that are keeping up with the literature, there's a lot of new findings that are coming out that the CDC is lagging quite far behind on. The most top of the mind one is that for current COVID variants, the peak viral load, what is going to be detected on rapid tests, isn't occurring until days 3 to 5 of after symptoms starting, which means that based off of the CDC's current rapid antigen testing requirements, when they're saying test 24 hours and 48 hours after symptoms start, and if you're negative, you're good to go, well, that's wrong. Because if you're not testing positive until on day 3 to day 5, then that's going to be completely missed. Furthermore, if you're not testing positive on a COVID rapid test, even though you are sick with COVID, until that 5th day, then you're not going to be able to get Paxlovid, because you have to start Paxlovid before the 5th day of symptoms through current recommendations. So would that then be classified as misinformation, even though it's accurate because it's against what the current CDC policy guidelines are? So this is a very problematic, disturbing thing that could be happening. So going back to the damned if you do, damned if you don't type statement, if they decide that COVID misinformation is protected free speech, that's going to be hugely problematic, as we're going to see people like Ron DeSantis and Florida's Surgeon General Ladapo taking full advantage of that. But then if they're saying that it is not protected free speech, then where is this line going to be drawn? And that drawn line could then become very problematic if it is not drawn appropriately.